They told him he couldn't build a garage on land he'd paid for, so he made sure they could never build anything again. His name was Robert Thornton, 62 years old, retired pipe fitter, 38 years in the trade, never missed a day, never filed a complaint. Bought his first home at 23 with cash he'd saved working double shifts. Paid it off in 11 years. In 2004, he bought 40 acres in rural Catron County, New Mexico. Middle of nowhere. Nearest neighbor 3 miles out. No HOA. No covenants. No restrictions. That's why he bought it. Cost him $78,000. He paid in full. The land sat empty for 2 years while he finished his last contract in Albuquerque. He wasn't in a hurry. He'd earned the right not to be. In 2006 he retired. Sold his house in the city. Bought a used fifth-wheel trailer and parked it on his land. No mortgage. No rent. Just his property, his trailer, and 40 acres of high desert he could see from horizon to horizon every morning. First thing he wanted to build was a garage. Nothing fancy. 30 by 40 feet. Metal frame. Concrete slab. Place to keep his tools, his truck. Maybe work on an old Chevy he'd been thinking about restoring for 15 years. He didn't need permission. The county had no building codes for unincorporated areas under certain square footage. He checked. Twice. But he did it right anyway. Drew up plans. Showed them to a friend who used to do inspections. Friend said it was overbuilt if anything. Good enough. Robert ordered materials. Had them delivered. Started laying out the foundation himself. That's when the county showed up. 2 trucks. One was code enforcement. Other was the county planning director. Man named Gerald Hackett. 41 years old. Tucked-in polo shirt. Clipboard. Sunglasses hanging from a lanyard. Hackett got out and didn't introduce himself. Just walked up and said, "You got a permit for this?" Robert wiped his hands on his jeans. Said, "Don't need one. Check the code. Unincorporated area, under 2,000 square feet, no permit required." Hackett smiled. Not a friendly smile. The kind of smile that comes before bad news. He said, "That changed 6 months ago. New ordinance. All structures now require permits and inspections. Even out here." Robert asked when the ordinance passed. Hackett said March. Robert asked where it was posted. Hackett said county website. Robert said he didn't have internet. Hackett said that wasn't his problem. Robert asked if there was a grace period for projects already started. Hackett said no. Robert asked what he needed to do. Hackett handed him a packet. 12 pages. Application fee, $250. Plan review fee, $375. Inspection fees, $200 per phase. Estimated processing time, 6 to 8 weeks. Maybe longer. Robert looked at the packet. Looked at the concrete forms he'd just spent 2 days setting. Looked back at Hackett. He said, "This is my land." Hackett said, "And this is the law." Robert asked if he could finish what he'd started and apply retroactively. Hackett said no. Said if Robert poured that slab without a permit, the county would red tag it. Make him rip it out. Fine him $500 a day until he complied. Robert didn't argue. He thanked Hackett for his time. Said he'd stop work and apply for the permit. Hackett left. Robert didn't pour the concrete that day. He spent the evening reading the ordinance Hackett mentioned. All 47 pages of it. Passed by the county commission in a 3-2 vote on March 19th. Published in the county legal notices section of a newspaper Robert had never heard of. Effective immediately. The ordinance gave the planning director broad discretion over all building projects. Required detailed engineered plans for any structure over 400 square feet. Required licensed contractors for all work. Prohibited owner-built projects except under direct supervision. In other words, it made it almost impossible to build anything yourself. Robert had built his own deck in Albuquerque. Built a workshop. Built a pergola. Never had a problem. Never had an inspection fail. Now, at 62 on his own land in the middle of nowhere, he needed permission. He filled out the application. Paid the fees. Submitted his plans. 6 weeks later, the county sent him a rejection letter. Reason: plans not prepared by a licensed engineer. Robert called the planning office. Asked if he could hire an engineer to stamp the plans he'd already drawn. They said no. Engineer had to prepare the plans from scratch. Robert asked how much that would cost. They said probably $1,500 to $3,000. Depended on the engineer. For a 30 by 40 garage. On his own land. Robert didn't get angry. He got an engineer. Cost him $2,200. Engineer looked at Robert's plans and said they were fine. Redrew them on CAD. Stamped them. Sent them in. 4 weeks later, another rejection. Reason: insufficient drainage plan. Robert called again. Said the land was flat desert. No drainage issues. Nearest structure 3 miles away. Planning office said new ordinance required drainage calculations for all impervious surfaces over 500 square feet. Robert asked what that meant. They said hire a civil engineer. Robert hired a civil engineer. Another $1,800. Engineer came out, looked at the land, said this was bureaucratic nonsense but he'd do the report. 2 weeks later, Robert had a drainage plan. Submitted it. 3 weeks later, approved. Permit issued October 19th. Total cost so far, $5,125. 4 months of waiting. Robert ordered materials again. Some had been returned. Some he'd kept under tarps. Started the project over. Got the foundation poured. Passed inspection. Framed the walls. Passed inspection. Put up the roof trusses. Passed inspection. Everything by the book. Then the county showed up again. Different inspector this time. Younger guy. Maybe 30. Looked at the structure and said the roof pitch was wrong. Robert said it matched the approved plans exactly. Showed him the stamped drawings. Inspector said he didn't care. Said the pitch exceeded the county's aesthetic guidelines for rural structures. Robert said there was no such guideline in the ordinance. Inspector said it was in the supplemental design standards. Adopted in July. Robert asked where he could see those standards. Inspector said county office. Robert drove to the county office. 53 miles. Asked for the supplemental design standards. Clerk said they didn't have copies available. Said he could request one in writing. Robert requested one in writing. 2 weeks later he got a PDF. 89 pages. Buried in Section 12 was a guideline recommending roof pitches not exceed 6 and 12 in rural areas to maintain visual harmony with the natural landscape. Robert's garage was 7 and 12. Same as the engineered plans. Same as the approved permit. He called the planning office. Asked why this wasn't flagged during plan review. They said it was a recommendation, not a requirement. Robert asked why the inspector red tagged him then. They said the inspector had discretion to enforce aesthetic standards. Robert asked what he was supposed to do. They said redesign the roof. Robert said the trusses were already up. They said take them down. Robert asked if the county would reimburse him. They said no. Robert didn't take them down. He filed an appeal. County ordinance allowed appeals to the Board of Commissioners. Cost to file, $150. Hearing scheduled 8 weeks out. During those 8 weeks, Robert got 3 more notices. One for an alleged drainage issue that didn't exist. One for construction debris that was neatly stacked and tarped. One for failure to post a permit placard in a visible location. He had posted it. On the front of the structure. Inspector said it wasn't visible enough from the road. Road was half a mile away. Each notice came with a warning. Failure to comply may result in fines, stop work orders, or permit revocation. Robert documented everything. Took photos. Saved every letter. Every email. Every receipt. Appeal hearing was December 14th. Robert showed up. 3 commissioners. Gerald Hackett sitting in the corner. Small room in the county building. Fluorescent lights. Fake wood paneling. Robert presented his case. Showed the approved plans. Showed the inspector's red tag. Showed the supplemental guidelines that were never mentioned during review. Explained he'd spent thousands of dollars and months of time following every rule, and now the county was inventing new ones. He didn't raise his voice. Didn't curse. Just laid it out. First commissioner, older man, rancher, asked Hackett why the roof pitch issue wasn't caught during plan review. Hackett said the supplemental guidelines were new and staff was still learning them. Second commissioner, woman, asked if the guideline was mandatory. Hackett said it was recommended but inspectors had discretion. Third commissioner, younger guy, asked if the county had ever enforced this before. Hackett said this was the first case. Rancher commissioner looked at Robert. Said, so you're telling me you followed every rule, paid every fee, passed every inspection, and now we're telling you to tear down your roof because of a guideline that didn't exist when you started? Robert said yes, sir. Rancher said, that's horseshit. Voted to overturn the red tag. Woman commissioner agreed. Voted to overturn. Younger commissioner abstained. 2-0. Robert won. Hackett looked like he'd swallowed a lemon. Robert thanked the board. Walked out. Drove home. Finished his garage. Final inspection scheduled for January. Inspector showed up. Different guy again. Older. Looked tired. Walked around the garage. Checked the roof. checked the foundation, checked the electrical, said everything looked good. Robert asked if they were done. Inspector said yes. Robert asked for the signed inspection report. Inspector said he'd email it. 2 days later, Robert got an email. Inspection failed. Reason: structure encroaches on required setback. Robert read it 3 times. Setback requirement was 50 feet from property lines. He'd measured. His garage was 73 feet from the nearest line. He called the inspector. Inspector said he didn't measure from the property line. He measured from the access easement. Robert said there was no access easement on his land. Inspector said yes, there was. County recorded it in 2003. Robert said he bought the land in 2004. No easement was disclosed. Inspector said that was between Robert and his title company. Robert pulled his title report. No easement listed. He went to the county assessor's office. Asked to see the easement. Clerk pulled the record. Easement filed November 2003. 20-foot strip along the western edge of Robert's property. Purpose: future county road access. Robert asked what future road. Clerk didn't know. Robert asked if the road was ever built. Clerk said no. Robert asked if there were any plans to build it. Clerk said not that she knew of. Robert asked who authorized the easement. Clerk said planning department. Robert asked if landowners were notified. Clerk said it should have been mailed. Robert said he never got a notice because he didn't own the land yet. Clerk said she couldn't help with that. Robert went back to the planning office. Asked to speak to Hackett. Hackett wasn't available. Robert waited. 2 hours later, Hackett came out. Saw Robert. Looked annoyed. Robert asked about the easement. Hackett said it was standard procedure. County reserved access easements for future development. Robert asked why it wasn't on his title report. Hackett said title companies miss things. Robert asked if the county notified the previous owner. Hackett said that was 10 years ago. He didn't have those records. Robert asked if the easement could be vacated since no road was planned. Hackett said no. Once recorded, easements were permanent unless the county released them. Robert asked how to request a release. Hackett said file a petition with the Board of Commissioners. Another hearing. Another wait. Robert asked what happened to his garage. Hackett said it violated the setback. Would have to be moved or demolished. Robert said the easement was never disclosed and he built in good faith. Hackett said ignorance of easements wasn't an excuse. Robert asked if the county would pay to move it. Hackett said no. Robert asked if he'd get his permit fees refunded. Hackett said no. Robert stood there. 62 years old. Retired pipe fitter. Man who'd followed every rule. Paid every fee. Done everything right. He said, "You did this on purpose." Hackett said, "I enforce the code." Robert said, "You're trying to run me off my land." Hackett said, "I'm doing my job." Robert didn't argue. He left. Drove home. Sat in his trailer. Looked at his garage. Finished. Perfect. 73 feet from the property line. 20 feet inside an easement nobody told him about. He didn't get angry. He got curious. Robert spent the next 3 weeks at the county offices. Public records are public. He requested every easement filed by the planning department in the last 15 years. 47 easements total. Every single one filed on unincorporated land. Every single one filed within 6 months before the land sold. Every single one filed without notifying the owner. Pattern was clear. County would identify private land near potential development areas. File easements. Wait for the land to sell. New owner wouldn't know. County could use the easement later to block projects, claim setback violations, or force landowners into expensive fixes. In some cases, the county never used the easements. Just left them there. Waiting. Robert pulled the commission meeting minutes from November 2003. Month the easement on his land was filed. No mention of it. No public hearing. No vote. He found the signature on the easement filing. Gerald Hackett. Planning Director. Hackett had signed off on all 47 easements. Solo authority. No oversight. Robert pulled the county ordinance governing easements. Easements over 5 acres required commission approval. Easements under 5 acres could be approved by the planning director if they served a public purpose. Robert's easement was .46 acres. Just under the threshold. But there was a requirement. Planning director had to certify the easement served an immediate or planned public use. Robert found the certification form Hackett had signed. Purpose listed: access for county road expansion, project CR 447. Robert requested the records for project CR 447. No such project existed. Never existed. Hackett had lied on a government document to create an easement that blocked Robert's garage. Robert made copies of everything. He didn't go to the county. He went to the state. New Mexico State Auditor. Office handles complaints about local government misconduct. Robert filed a formal complaint. Attached 53 pages of evidence. Every easement. Every false certification. Every pattern of abuse. He didn't ask for money. He asked for an investigation. State Auditor opened the case in March 2007. Took them 4 months. In July they released their findings. Gerald Hackett had filed 47 illegal easements over 9 years. Had falsely certified public purpose on 32 of them. Had used easements to selectively enforce codes against property owners he wanted gone. Had created a system where he could trap landowners in bureaucratic loops that cost them thousands of dollars while benefiting county contractors he had relationships with. The audit found no evidence Hackett took bribes. But it found he exceeded his authority, violated state law, and abused his position. Auditor referred the case to the state attorney general. Attorney General opened a criminal investigation. By October, Hackett was suspended. By December, he was charged with 32 counts of misconduct in office. He pleaded guilty to 4 counts. Sentenced to 1 year in county jail, suspended. 3 years probation. Permanent ban from holding public office. The county was ordered to vacate all 47 easements, including Robert's. By February 2008, Robert's garage was code compliant. No setback violation. No easement. Nothing. He got a letter from the new planning director. Apologizing. Offering to refund his permit fees. Robert didn't respond. He didn't need an apology. He needed what he'd always needed. To be left alone. But Robert wasn't done. Because while he was digging through county records he found something else. In 2005 the county commission passed the building ordinance that started all this. The one that required permits, engineers, inspections. Robert pulled the meeting minutes. 3 commissioners voted yes. 2 voted no. One of the yes votes, Commissioner Bill Hodge. Hodge owned a civil engineering firm. Same firm Robert had been forced to hire for the drainage plan. Conflict of interest is illegal in New Mexico for elected officials who financially benefit from ordinances they vote on. Robert filed a second complaint with the state auditor. This one took 6 months. In August 2008, the auditor confirmed. Commissioner Hodge's firm had earned over $200,000 from county building projects since the 2005 ordinance passed. Hodge never disclosed his financial interest. Never recused himself. Hodge resigned in September. The county commission, now with 2 new members, voted 4-1 to repeal the 2005 building ordinance. Catron County went back to the old rules. No permits required for small structures in unincorporated areas. The way it was before Gerald Hackett decided he knew better. Robert Thornton never sued the county. Never asked for his money back. Never gave an interview. In 2009, a reporter from the Albuquerque Journal tracked him down. Asked if he wanted to tell his story. Robert said no. Reporter asked why he went through all that trouble. Robert said, because it was my land. And I don't let people steal what's mine. Reporter asked if he thought he'd changed anything. Robert said, I didn't do it to change anything. I did it because it was right. The garage is still there. 30 by 40 feet. Metal frame. Concrete slab. Robert finished restoring that Chevy in 2011. Took him 2 years. Did all the work himself. In his garage. On his land. He sold the truck in 2013 for $18,000. Bought a used Harley. Rides it when the weather's good. He's 79 now. Still lives in the same fifth wheel on the same 40 acres. No mortgage. No HOA. No permits. The county leaves him alone. Not because they're nice. Because they learned. You can push a man. You can bury him in paperwork. You can charge him fees and make him wait and treat him like he doesn't matter. But if that man knows he's right and he's willing to do the work, and he's got nothing but time and principle on his side, you're going to lose. Not loudly. Not quickly. But completely. Robert Thornton didn't just beat the county. He beat the system that let the county think it could do this in the first place. And he did it the way men like him always do. Quietly. Thoroughly. And permanently. If you've ever been told you can't do something on your own land, you know exactly how this feels. Drop a comment if you've dealt with this. And if you're dealing with it now, remember Robert's lesson. Document everything. Know the law better than they do. And never ever stop.